So it's midday on Friday, and literally as I'm speaking, in the Southern District of New York, closing arguments are taking place in Sarah Palin's defamation action against the New York Times. I've been talking about this on radio as well as on CNN. I'm keenly interested in this case for a whole variety of different reasons, not the least of which is what I do for a living, but also because in my prior life as a trial attorney, I sometimes handled defamation actions. Not too many do. You don't often see cases go to trial for defamation. It's almost like the insanity defense. They get outsized influence in the media because when there is a case that actually makes it to trial, when someone asserts an insanity defense or in a civil realm, when someone files a lawsuit for defamation, chances are they're a public figure and we're naturally inclined to watch. So what's this all about and what's expected to happen? Let me say at the outset that the odds are against Sarah Palin. I expect that she will lose at trial for reasons I'm about to describe. I think she probably knows the odds are against her. She's not playing for the Southern District of New York jurors. She's playing long ball. She wants to get her case before the Supreme Court of the United States in the hope that there will be a reassessment and overturning of New York Times versus Sullivan, which is the law of the land and has been, I think, for about 65 years in defamation actions that concern public officials, people with some degree of a public profile. What's this all about? This is about a 2017 editorial that the New York Times ran on the day, literally on the night of the baseball congressional shooting incident that so severely wounded Steve Scalise. Remember, Republicans were practicing because at the time, and I think it's still the practice, there would be this Republican-Democratic baseball game that they would play at the Nationals ballpark in anticipation of that not-for-charity public exercise. They were having practice. And some deranged individual, who I think happened to be a Bernie Sanders supporter, if that matters, shows up, opens fire, and severely wounds Scalise. The New York Times that day wanted to write about the connection between that shooting incident and the vile political environment in the United States. So a New York Times writer, whose name is Elizabeth Williamson, was given the task of writing the editorial, and Williamson did so and then sent it up the food chain to James Bennett, the editorial page editor. He tinkered with it. It was then published that night electronically and the following morning in the New York Times print editions, and it was wrong with regard to Sarah Palin. It drew a causal connection between Palin and, more specifically, her political PAC and something her PAC had done 6 years prior. It drew a causal connection between Palin and the shooting of Congresswoman Gabby Giffords. The Times was wrong. The Times, I argue, was clearly negligent in what they did. But negligence is not the standard. Actual malice is the standard, and whether Palin can meet an actual malice standard, therein lies the doubt, and therein lies the high hurdle of her case. A couple of more details, if I might. So Elizabeth Williamson writes an editorial and sends it to James Bennett. This is the afternoon of the shooting incident where Steve Scalise was victimized. Let me just read one paragraph. It says this, and this is the way that Williamson, this was her original version. Just as in 2011, when Jared Lee Lochner opened fire in a supermarket parking lot, grievously wounding Representative Gabby Giffords and killing 6 people, including a 9-year-old girl, Mr. Hodgkinson's rage was nurtured in a vile political climate. Then, meaning 6 years prior, it was the pro-gun right. It was the pro-gun right being criticized. In the weeks before the shooting, Sarah Palin's Political Action Committee circulated a map of targeted electoral districts that put Ms. Giffords and 19 other Democrats under stylized crosshairs. Well, there's a problem with the way in which it was written by Ms. Williamson, because a map of targeted electoral districts did not put Gabrielle Giffords and other Democrats under stylized crosshairs. It put their congressional districts under stylized crosshairs. In fact, if I have a diagram of the way it originally looked, I'll show it to you. Yeah. I don't know if you can see it, but that's stylized crosshairs on congressional maps, not on members. So that is one issue with the original version of the editorial, but it gets worse. Mr. Bennett now spends time working on it, changes some of the language, adds language, and I'll now read the final paragraph of the editorial. Was this attack evidence of how vicious American politics has become? Probably. In 2011, when Jared Lee Lochner opened fire in a supermarket parking lot, grievously wounding Representative Gabby Giffords and killing 6 people, including a 9-year-old girl, key words now, the link to political incitement was clear. Before the shooting, Sarah Palin's Political Action Committee circulated a map of targeted electoral districts that put Ms. Giffords and 19 other Democrats under stylized crosshairs. The key words are, the link to political incitement was clear. Those words were added by James Bennett, the editor of the editorial page of the New York Times, but they were false. There was never a causal connection established between the shooting in the Gabrielle Giffords case and Sarah Palin's PAC. And the New York Times, getting called on this that day, that night, I should say, published a correction. But they'd already published false and defamatory information about Sarah Palin, and that's why she's suing. What came to light during the course of the discovery phase and then the trial is the Times' acknowledgement of the mistake and how it all went off the rails. I'm reading from Josh Gerstein's coverage at Politico, just 2 paragraphs. He writes, the former Times editor said under questioning, that's James Bennett, that the one reason the disputed passages were not flagged sooner was that the original drafter of the editorial, Elizabeth Williamson, did not carefully read the final copy after it was sent to her by email twice in the process. Times staffers call, quote-unquote, playback. So you see what happened here. Williamson writes the original draft of the editorial, sends it to Bennett, he changes it, he adds the causal connection that was false, sends it back to her, apparently twice, but she didn't pay attention to it, or at least she didn't do anything about it. In the trial, Bennett testified, quote, this is my fault, right? I wrote those sentences, and I'm not looking to shift the blame to anyone else, so I just want to say that. But yeah, I mean, this is why we send playback to writers, because they're the ones who reported the story, Bennett said. They're the ones who are in possession of the facts, and it's important for them to review pieces to make sure that others haven't introduced errors. And he, Bennett, had introduced an error in this case. So you might be listening to this and saying to yourself, well, Michael, if it's the way that you've presented it, it sounds like Sarah Palin has a pretty strong case. Sarah Palin would have a strong case if she weren't a public figure, because the New York Times versus Sullivan case stands for the following proposition, that if you're a person without a public profile, without a public persona, and you're defamed, you're subject to libel, which is written, or slander, which is spoken. It's a simple negligence standard. Did someone fail to exercise reasonable care when they spoke about you or when they wrote about you? But if you're a public figure, the law presumes, and this was long before the internet, the law presumes that you have a platform available to you to defend yourself. And so the standard is one called actual malice, which means knowledge of falsity or reckless disregard for the truth. So Sarah Palin needs to establish several elements to be successful in this case. But at the core, she needs to establish that either the New York Times had knowledge of falsity or exhibited reckless disregard for the truth. Those are 2 different things. As far as I know, and I've paid close attention to this trial, there's been no evidence forthcoming of a knowledge of falsity on the part of the New York Times. In other words, Elizabeth Williamson, James Bennett, each had a hand in the final product, But there's no evidence I'm aware of that they were acting with a malice toward Palin, like we're going to get her back, even though we know what we're publishing is false. No evidence of that I'm aware of, which leaves Palin reliant upon reckless disregard for the truth. And I think it's conceivable that the jurors could conclude that given the back and forth between Williamson and Bennett adding lines and Williamson not taking note of them and Bennett making a causal connection that was false, I think arguably the jurors could find that that was reckless, that they had a reckless disregard for the truth. Recklessness obviously is something more than negligence, more heightened. Here's the problem for Palin. The problem for Palin is that, as I understand it, and I'm delivering these remarks while the closing arguments are going on and before the judge instructs the jury on the law, but my understanding is that based on the New York Standard jury civil instructions, that the judge is going to define recklessness or reckless disregard the following way. And I think that this is a problem for Palin. I also think it gives her an appellate issue. Remember, the standard, actual malice, knowledge of falsity, or reckless disregard for the truth. And that's what the Supreme Court says. So the New York Standard jury instruction, as I understand it, holds the following. Reckless disregard means that when defendant made the statement, he or she had serious doubts as to the truth of the statement or made the statement with a high degree of awareness that it was probably false. If that is the way that the jurors are instructed, and if they follow that instruction, because there's something called jury nullification. You know, jurors, when they get behind closed doors, can do whatever the hell they want to do. But if that is literally followed by the jurors in the Palin case, then I don't know how they can find for her. Because that definition doesn't sound to me like reckless disregard for the truth. If I were Sarah Palin's lawyer, I would be vehemently arguing against that charge being given to the jury, because that's not a definition of reckless disregard for the truth. That's a definition of knowledge of falsity. They are two totally different things. Let me read it one more time. Reckless disregard means that when defendant made the statement, he or she had serious doubts as to the truth of the statement. Let me stop there. There's no knowledge, there's no evidence in this case that I'm aware of that Bennett or Williamson or anybody else at the New York Times had serious doubts about the truth of what they were writing. Second part, or made the statement with a high degree of awareness that it was probably false. They sound like the same thing. And that doesn't sound to me like reckless disregard for the truth. That sounds to me like knowledge of falsity. So that's why I am suspect of Palin's ability to win in the Southern District of New York. Again, she's playing long ball, where Justices Thomas and Gorsuch have already said things suggesting that they are open to another look at New York Times versus Sullivan. She's hoping to get this case before the Supreme Court of the United States. And by the way, she or her lawyer made this choice of forum. She could have filed this action in Alaska. She wanted the attention that has attached to this trial, probably knows that she will lose, but she hopes it gets before the Supreme Court. And you know who else is hoping for that? Someone sort of standing in the tall grass who himself has been advocating for a re-examination of America's laws of defamation, and that would be one Donald J. Trump. The final thought that I have is keep this in mind. The principles transcend Palin and transcend Trump. So I encourage people who are paying attention to this case not to really think, am I for or against Palin, but rather, do I believe in a standard that holds a public official accountable for meeting a much higher burden in suing for defamation than a normal citizen or somebody who's outside the limelight. Final thought is that the internet, I think, has also, sort of redefined who's a public figure. So many people are public figures these days because they've got a big following on Twitter or on Instagram or on Facebook. So it's a really interesting case. And don't put on your partisan jersey based on the fact that Palin is the plaintiff. But Sarah Palin is hoping that, henceforth, defamation law in the United States won't be New York Times versus Sullivan. It will be Palin v. New York Times. Thanks for watching.